Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to the Deep Dive. Today we're looking into a really significant legal shift affecting employment law. It centers around a former health system employee, Bethany Shear, and her employer, Sisters of Charity of Leavenworth Health System, or SCL.
Exactly. Our source material is the 2025 10th Circuit ruling, Shear v. Sisters of Charity. And this case is, well, it's absolutely crucial because it's one of the first big ones applying a brand new lower standard set by the Supreme Court for workplace discrimination claims.
So this isn't just academic theory.
Not at all. This directly impacts how employers have to handle concerns about employee behavior, mental health right now.
Okay, so our mission today is to unpack Bethany Shear's story, her job at SCL, the mandatory mental health counseling situation, and ultimately her firing. But maybe even more importantly, we need to get into the legal shift itself, this Muldrow decision, which basically revived her case when it seemed dead in the water. Okay, let's unpack this.
So Bethany Shear, she worked for SCL in their physician billing department. Her role was Patient Accounts Representative I, and she was there from 2014 up until 2019.
And for a lot of that time, the relationship seems, well, a bit rocky. Focused mainly on her job performance.
That's right. If you dig into SCL's records, there's a clear paper trail. Shear had 7 different corrective actions noted between 2014 and 2018.
7, wow.
Yeah, and almost all of them were about not hitting her monthly productivity targets. Her supervisors, Osborne and Stoll, they saw this pattern. She'd have low output for most of the month, then this kind of last-minute scramble, lots of stress, to try and meet the goals.
So by August 2019, they decided to act.
They did. Supervisors Osborne and Stoll drafted a performance improvement plan, a PIP. Pretty standard stuff, really. They intended it as a tool, not disciplinary, just to help her get more consistent.
Right, just address the productivity.
That was the plan initially, but then things changed dramatically around August 22nd and 23rd of 2019. The focus shifted sharply from just performance to a perceived crisis.
How so?
Shear apparently shared some deeply personal issues with several coworkers, and those coworkers reported feeling seriously concerned about her well-being, her safety even.
Okay.
One supervisor, Stoll, actually relayed concerns to HR, mentioning talks of suicide or possibly suicidal ideations.
Okay, that definitely shifts the dynamic.
Right.
So once HR gets involved, what happens to that standard PIP?
Well, the HR director, Karen Oxenford, got these reports, and the PIP was immediately overhauled. It wasn't just about billing quotas anymore.
What did they add?
They added a very specific mandatory requirement. She had to be referred to SCL's Employee Assistance Program, the EAP. This was handled by an outside company, New Directions, and crucially, this counseling wasn't just suggested, it was made an explicit condition of her keeping her job.
Wow, a condition of employment.
Exactly. And this is where it gets really complicated. Shear, initially, she said something like she was not opposed to seeing someone for help. She seemed okay with the basic idea of the PIP. But the mandatory EAP part required her to sign a specific document, a formal referral form, the FMR form. And that form became the major sticking point.
Why? What was on it?
It wasn't just a simple privacy release, you see. By signing it, Shear would authorize the EAP provider, New Directions, to report 2 specific things back to her employer, SCL.
Okay, what were they?
First, simply whether she attended the counseling sessions. Second, and this is key, whether she complied with whatever recommendations the EAP made.
So SCL would know if she was following the therapist's advice.
Essentially, yes, at least in terms of compliance. And Shear refused point blank to sign it. She argued it was overbroad, a potential ADA violation, and a serious invasion of her privacy.
Especially since she maintained she wasn't actually mentally ill or a danger to herself.
Precisely. Her concern was that SCL was basically getting oversight, control over intimate details of her potential mental health treatment simply as a term of keeping her job.
How did SCL react to her refusal?
They didn't budge. From their perspective, signing that FMR form was a mandatory part of complying with the PIP. It was non-negotiable.
And she kept refusing.
She was suspended without pay. They gave her a final deadline to sign the form, and when that passed, on September 4th, 2019, she was fired. The reason given was failure to comply with the conditions of the PIP.
Okay, so that leads to the lawsuit. What was her specific legal argument?
This is really important. She sued under the Americans with Disabilities Act, the ADA, specifically using the regarded as disabled prong.
Meaning she wasn't claiming she had an actual disability.
Correct. Her argument was that SCL terminated her based on their erroneous perception that she suffers from a disability of mental illness. She argued they acted based on, quote, myths, fears, and author stereotypes, not on any actual inability to do her job or concrete evidence of being a danger. The firing, she claimed, stemmed from their perception, their fear.
What's fascinating here is how this played out legally. SCL actually won the first round, didn't they?
They did. And it really highlights how quickly legal standards can change. When Shear's case first went to the district court, the judge applied the existing law in that circuit, the 10th Circuit.
And that law made it hard for her.
Very hard. The standard came from a 1998 case, Sanchez. To prove discrimination under the ADA or Title VII, an employee had to show they suffered an adverse employment action. But Sanchez defined that action really narrowly.
How narrow? What was that old standard?
It had to be a significant change in employment status. Think big things. Getting fired, being demoted, not getting a promotion you were qualified for, or maybe being reassigned to a job with vastly different, usually worse responsibilities. It was a high bar.
Like a wall the plaintiff had to climb over, basically.
Exactly. A pretty high wall. So the district court looked at the mandatory EAP referral, even with that controversial FMR form, and said, okay, maybe it's invasive, maybe it's inconvenient, but is it a significant change in her job status, like a firing or demotion?
And the answer was no.
The answer was no. At that point, the referral itself wasn't the firing. It was just a condition leading to the firing if she refused. So under that old high standard, the court dismissed her case. The wall was too high.
But then everything changed.
Everything changed. In 2024, after the district court dismissed Shear's case, the U.S. Supreme Court dropped a bombshell ruling, Muldrow v. City of St. Louis.
And Muldrow wasn't even an ADA case, right?
Correct. It was actually a Title VII case about alleged sex discrimination involving a job transfer. But the impact was massive because the Supreme Court explicitly rejected that whole significant change test. They said that standard was wrong, not just for Title VII, but implicitly for other federal discrimination laws that use similar language, like the ADA.
Wow. So the Supreme Court just tore down that high wall for potentially all federal discrimination claims, race, sex, religion, disability.
That's the implication. It lowered the burden significantly. So if the old standard was that high wall, what's the new one?
What is the new standard after Muldrow?
The new rule is much simpler, much lower. Plaintiffs now only need to show they suffered some harm respecting an identifiable term or condition of employment.
Some harm, not significant harm.
Exactly. The Supreme Court clarified the employer's action must have left the plaintiff worse off, but need not have left her significantly so. It's no longer about proving a major change. It's just about showing you were disadvantaged in some tangible way related to your job.
So because Muldrow came out after Shear's case was dismissed.
The 10th Circuit Court of Appeals, in its 2025 decision reviewing Shear's case, basically said, hold on. They vacated the lower court's dismissal of the case.
Meaning they canceled the dismissal.
Right. They told the district court, the rule you use, the significant change rule, that's not the law anymore, thanks to Muldrow. You need to look at this again, using only the new lower sum harm standard.
Here's where it gets really interesting. Because the fight now isn't about whether the harm was big enough. It's about whether this kind of harm, forcing someone to potentially reveal sensitive health compliance info to keep their job, counts as any harm at all.
That's precisely the question the district court has to grapple with now, on remand. What does some harm actually look like when it's not about losing pay or a promotion, but about things like medical privacy and personal autonomy?
And SCL still has arguments, right? They didn't just roll over.
Oh, absolutely not. SCL has some strong points. They emphasize Shear's performance history, the fact the PIP was initially drafted before the suicidal ideation reports came in. They argue the EAP referral wasn't discriminatory retaliation for anything.
And didn't they use this EAP referral on someone else too?
Yes, that's a critical piece of their defense. They showed evidence that they had issued an identical mandatory EAP referral with the same FMR form requirement to a different employee. And that other employee was referred for general disruptive behavior with no mention of suicidal thoughts or mental health issues.
So SCL's argument is, look, this is just our standard procedure for certain behavioral or performance issues. We applied it consistently, not because we regarded Shear as disabled.
Exactly. That consistency argument is probably their best defense against the discrimination claim. Plus, they also point out something else Shear did after she was fired.
Okay.
Apparently, after her employment ended, Shear voluntarily went to 5 EAP sessions with the very same provider, New Directions.
Oh.
So SCL argues, see, She wasn't actually harmed by the referral itself. She later chose to use the service. How can the earlier mandated referral be considered harm if she ultimately found value in it?
Okay, wait though. Let me push back on that, especially under the new some harm standard. Just because she later went voluntarily doesn't erase the potential harm of being forced to agree to that specific FMR form as a condition of keeping her job.
That's Shear's counter-argument, precisely. The harm wasn't necessarily the counseling itself, it was the coercion. It was being forced, under threat of firing, to sign away a degree of control over her personal health information specifically, the compliance reporting back to SCL.
The mandatory nature and that specific form are key.
They are. Her argument is she wasn't just told, go get help. She was told, sign this form allowing us oversight into your EAP attendance and compliance or you're fired. That required disclosure, linked to the employer's action, which she claims was based on a perceived disability. They're regarded as part, that's the harm.
And if SCL acted because they wrongly perceived her as mentally unstable acting on a stereotype, maybe then demanding that invasive compliance info as a job condition.
Yeah.
That itself makes her worse off, doesn't it? It's a loss of privacy and autonomy that other employees didn't face.
Mm-hmm. This raises an important question. It highlights the core tension now. Can an employer have a policy, apply it consistently, like SCL did with the other employee, but still have it result in discrimination if the reason they applied it to Shear was based on a perceived disability, and that application caused this unique, non-monetary harm related to privacy?
So the debate has shifted. It's not, was the harm significant anymore? It's just, was there some harm, some disadvantage? And being forced to sign that waiver under threat of firing seems like a clear disadvantage.
It certainly seems easier to argue under the new standard. And you have to remember, she was suspended without pay and then fired, specifically because she refused to sign that form.
Right. The refusal was the direct trigger for the negative consequences.
Exactly. The mandatory requirement was the term of employment she wouldn't meet. The refusal triggered the disciplinary action, and termination was the ultimate result. Under the some harm test, connecting those dots is much more straightforward for a plaintiff. Which is why the case is back with the district court. They now have to decide if that compelled loss of privacy and autonomy qualifies under this lower Muldrow standard.
So what does this all mean? What's the big takeaway here?
Well, the key takeaway for you listening is pretty stark. The Muldrow decision means employers really need to be hyper-aware now. Actions that might have seemed minor before, things like mandatory EAP referrals, even changes in work schedules, specific types of monitoring, or lateral transfers with different duties, these can all potentially be seen as adverse employment actions if they leave an employee objectively worse off in some way.
Even if it's not about money or title.
Even if it's not about money or title. The bar for employees to bring discrimination suits under the ADA and Title VII has been lowered, quite dramatically, actually.
It feels like it really puts teeth into that regarded as disabled prong of the ADA.
It really does. Think about it. Shear's entire claim rests on SCL regarding her as having a mental illness based on those coworker reports based on, as she alleges, myths, fears, and stereotypes.
Right.
So if an employer acts out of what they might see as genuine concern, but that concern stems from an unfounded perception or stereotype about a disability, and that action forces the employee into a situation that causes some harm, like signing a coercive, privacy-invading form to keep their job. Well, the new Muldrow standard makes it significantly easier for that employee to argue that the employer's helpful intervention is, in fact, direct evidence of discrimination based on that perceived disability.
That's a really fine line for employers to walk now.
It is. Future cases are definitely going to be exploring this tension. Where does genuine, appropriate concern end and a legal action based on stereotyping begin, especially when the resulting harm isn't a demotion, but something more like a loss of autonomy or privacy? Muldrow has definitely shifted the legal ground here, and the advantage seems to have moved towards the employee.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to Carey at capclaw.com. That's capclaw.com.